Hello, welcome to another edition of Matters of Law. Thank you so much for watching our previous editions, and I'll urge you, as you're watching this, to share with friends. Join us on extvgh on YouTube and Explore TV GH on Facebook. Today, we are talking about that interesting subject, marriage. You would want to listen to a lot from us. Before then, let's go for a spot of commercial break.
The program is brought to you by PEG Enterprise. Call us on 0240 533 097 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near KK House in Ho Volta.
Welcome back. Today, we are talking about marriage. Marriage plays a very important role in the Ghanaian setting. Now, under Ghanaian law, there are three kinds of marriages that is recognized under our laws. We have the customary marriage, which people wrongly refer to as engagement, and the ordinance marriage, Cap 127, and the Mohammedans ordinance, Cap 129. Now let's concentrate on the customary marriage. Customs of people differs from place to place. So the customs of the people down south of Ghana is different from the customs of those who are in the north. Even among people who come from various places, the customs differ. So under customary law, there are things you are required to comply with. And once you have complied with all those provisions, then you are deemed to have been married under customary law. Remember, going to announce a pregnancy is not synonymous to marriage. So the practices or the customs which is required under marriage is what should be strictly followed. But do you know that when you get married under custom, you can get a marriage certificate, that is a customary marriage certificate? Oh yes, you are surprised. Indeed, you can get a customary marriage certificate. All you need to do is to get to the nearest district court or marriage officer's office for a statutory declaration to be prepared or an affidavit to be prepared stating the date the marriage was celebrated, the people who are available, and the appropriate custom that was used. You may provide some pictures as some form of evidence. Then voila, after that, you are issued with a customary marriage certificate. Remember, customary marriage is potentially polygamous. The man can choose to marry more than one wife or may marry more than one wife. It's not compulsory. So know what you're getting into. The other one is ordinance marriage, Cap 127. Remember, that is either going to court to get married or doing a wedding in a licensed church by a licensed minister. How do you start this process of ordinance marriage? You need to go and see the registrar of the district court within the locality where you want to celebrate the marriage, or you go to a marriage officer in any of the marriage officers' offices. What you do is that you'll be given a form called the Notice of Publication of Banns. What that form requires is for you to state your age, your profession, whether you're a spinster, whether you're a bachelor, whether you're a widow or a widower, and the other necessary details. Now remember, under our laws, when you are 21 years and above, you do not need parental consent to get married. But between age 18 and 21, you need parental consent. Now after this notice is filled, the registrar will post it on the notice board of the district court where you went to, and copies may be given to you to send to your various places for publication or for posting. Now that notice requires that it be posted for 21 days. Within the 21 days, if anybody has any issue with you being married, the person can raise it. And that is what we call a caveat. And the caveat could be, or the objection could be, that the man you are going to marry is a lady's husband or somebody's husband, or that man is already married to somebody else, or the woman you are going to marry is somebody's wife. When these objections are raised, what we refer to caveat, then the district court will determine the caveat or decide on it. If they do not find anything wrong, then you'll be allowed to go ahead. So within the 21 days, if nothing happens, then the next thing you do is to go to the registrar, where the registrar will require you to endorse or require you to prepare a statutory declaration or an affidavit. Then you are issued with a registrar's certificate. I believe a lot of you, this is the first time you are hearing that. Yes, indeed, there's a registrar's certificate. There's a unique number that is quoted. It is with this registrar's certificate that you go ahead to conduct or celebrate the marriage in a licensed church by a licensed minister to celebrate marriages. Or you can also continue with the district court magistrate for the marriage to be celebrated. It is important that you start this process at least 4 months to the date where you want to celebrate your marriage, so that you are not caught up with time. Now, during the celebration of the marriage, what you are required to do is to provide 2 witnesses for the side of the man and 2 witnesses for the side of the woman. Voila! That's all you need. They will sign the marriage certificate, after which you are given a copy. Remember, this is a very simple process, and in the law, there's no requirement for a wedding ring. Yes, I know you are surprised. There's no requirement for a wedding ring. What is most important is the exchange of consent. That is agreeing to marry the person once we are sure that you have satisfied the age requirement and you are not incapacitated by reason of maybe your thoughts or the way you are thinking, that you are a person who is sound and the person who knows exactly what you are entering into. Cap 129, that is the Mohammedans ordinance, is for our Muslim brothers. Marriage is a very good union, but it is highly respected. So you must go according to all the laws so that you do not falter. Thank you so much for joining us on extvgh on YouTube and Explore TV GH on Facebook. Share this to friends and let us know your comments and reviews. Join us in our next edition. A civil action. Now, the civil action will be between you and the person directly. So you can take a lawyer to sue that person, or you can go to the registrar of the court to help you to draft a writ that will be served on the person for the person to answer. Now, in other cases where you do not even have a criminal case, or you have just a normal civil case, maybe a land dispute with another person, or you have a contract with another